Can we have that plug back?
Yeah.
If you can spare it. Thank you. Thank you very much. Good device to get something like this for court.
All rise if able.
Thank you, my lord. I wonder if I might go back to the point my lord made shortly before the short adjournment, that with a young child, it's pretty obvious that the
If the evidence shows it is.
If the evidence shows it is, yes. But it doesn't obviate the need to look at all the options in the round and conduct a holistic analysis. And on that topic, I wonder if I might refer the court to ReLC at page 349 in the authorities bundle. That was a case of a 2-year-old with older brothers aged 7 and 8. And the judge had refused.
Sorry, the references to which page?
349, my lord.
Electronic.
Electronic.
Yep.
ReLC. Yeah, 2-year-old child, older siblings 7 and 8. And the judge had declined to make a placement order on the basis that this child's relationship with siblings was important, and that when balanced against the permanence that would come from adoption, the benefit of being brought up as part in knowledge of siblings outweighed the advantages of adoption.
Right, so in that case, just looking at the third note 2, 7 and 8, and the issue there was they'd been together, but then they had to be separated.
Yes.
And the local authority wanted a placement order for the youngest child, the guardian didn't.
Yes, I accept that there is that difference, that one professional supported that. But if we go to page 363, paragraph 44, the recorder did engage with the advantages of adoption. That with the criticism made of the recorder was that there wasn't a full analysis, and the court said, or Justice Baker said, that reading the two judgments that the whole recorder did engage with the advantages of adoption as identified by the local authority, but concluded that in the circumstances they were outweighed by the disadvantages. And then there's the reference
That was a Roma case.
It was. No, there's another case which is a Roma case. Hungarian Roma, yes, this is a Roma case as well. But it wasn't simply the cultural reasons.
No, I understand that. I'm just looking at the
Yeah.
at what the recorder did in that case. Recorded at 23.
Yes.
Looking at it overall.
Obviously the facts are different, but the ages are not that different. And my point is that, as the judge says in paragraphs 44 and 45, you still have to do the proper holistic welfare analysis of all the options, but it's understandable in cases where there are siblings that a major focus, perhaps the major focus, if one looks at paragraph 45, is that the effect of adoption is to sever the child's relationship with all members of their birth family, and then the reference to Re B and the what Lady Hale described as the test for severing the relationship.
So what are you showing us this for?
That to say that because a child is young, it is obvious, or there must be magnetic importance given to the stability that comes from an adoptive placement.
Well, this is an instance of a case where a rather older child had established relationships, and where the
yes,
where so much so that there was a division of professional opinion about it, and there was no doubt that fostering together was a realistic option.
yes. Well, in this case, the local authority has not suggested that it's not a realistic option.
Sorry?
The local authority in this case did not suggest that it wasn't a realistic option, in the sense that
I thought one of the complaints that you were making was that the Sweat statement didn't include it as a realistic option.
The earliest Sweat statement of the 17th of October 2023 includes 3 different options.
Right.
And it may be worth looking at that. But may I just refer briefly, while we're in the authorities bundle, to 2 more authorities. Re-N, refusal of placement order, which is at 399. Oh, I'm so sorry, I think that's, yes, here we are. These were also young children. And in that case also, a placement order was refused. And it was a case in which the judgment was not particularly clear in terms of its evaluation. If we go to paragraph 33 on page 412, there wasn't an evaluation of the various factors one against the other. But in paragraph 34, reading the judgment as a whole, it's clear that the judge factors relevant to his decision. He acknowledged the greater degree of permanence and security provided by adoption rather than fostering, and so on. And it's clear, paragraph 35, that the magnetic factor in the judge's estimation was the importance of the sibling relationship. And so on that basis, the judge was right to conclude, or entitled to conclude, that a placement order should not be made on the basis that nothing else would do. Another case is Re T&R, and that's in the bundle at page 366. It was a case involving 6 children, and the issue was whether the younger 2 children should be the subject of a placement order, thereby...
I'm sorry, I beg your pardon, I don't want to slow you down, but I was just looking at the facts of the last one, which was N.
399.
Were those 2 children in placement together?
No, if one looks at paragraph 3, paragraph 8, since the hearing, N has remained with her foster care, but G has moved to live with her father. I think they had been together.
So one of the children was in a family placement.
One of the children was in a family placement, yes. I accept that's a difference on its facts. But
I mean, I think what we're needing to get out of these is point of principle.
the principle is that one has to, in every case, look at the various factors pertinent to that case. And in this case, all the professionals highlighted the importance of contact not only between the siblings, but also between the siblings and the parents. And that was a given. Nobody disputed that these were parents who were not able to look after their children, but were otherwise good people who would be of benefit to their children as they grew up, and likewise the sibling relationship would be of benefit to see as she grew up. And so the judge was right to factor that into the balance, and he clearly came to the conclusion, as we say he was entitled to do, that the importance of those relationships was such that it outweighed the advantages to see of adoption. And of course, this court will be aware that there are permanent foster placements that are permanent. Of course, it carries risks of having to move and so on, but a foster placement which could meet the needs of all the children would certainly be something which would have advantages for them. And when the local authority first dealt with it in their statement in October, they did consider the three options and said that, and did not suggest that there would be a difficulty finding a placement for all three children together, or that it was somehow going to be difficult. I know I submitted earlier that they'd always only considered two options, but having looked at it again over the short adjournment in October, they were considering all three and were not putting forward difficulty in placement or anything like that in the balance when they did the balance in relation to those two options. In respect of, sorry.
So when you say that, I'll just paraphrase that last submission.
Yes.
So I'm not on top of the detail as you describe it that you looked at over lunch, but you say the judge was effectively entitled to take into account the potential benefits for C of being in foster care together with her half siblings.
Yes.
And through that in contact with her parents.
Yes.
And the judge was entitled to take the view that that outweighed the benefits of adoption.
Yes.
I think the criticism is that he didn't really actually conduct that weighing exercise against the benefits of adoption. It's not that. I mean, as I understand it, the criticism is that there isn't. It's a one-sided evaluation in effect.
That is the criticism.
Doesn't your submission have to be directed slightly differently to actually demonstrate that he did conduct the appropriate balance before coming to the conclusion?
I think I've conceded that the judgment is not structured as well as it should be, but I do rely on those authorities which say the judge doesn't have to go through every point. He doesn't have to set out in his judgment every single piece of evidence that he's taken into account. He does show in our submission that he had factored in the benefits of adoption by recognising that this was a young child, that her age was a very important matter in the balance, that she was still at an age where she could form attachments to adopters, not so in the case of the older children. He recognised that there were disadvantages in foster care, and our submission is that if you put the judgment together, it is all there, and it does show that he had in mind the positives as well as the negatives. He doesn't do the balance sheet analysis that is the ideal in a case like this. But the authorities that we've looked at make clear that that isn't fatal to a judgment. As long as it's clear that he's considered everything that's relevant,
No,
he doesn't have to do
he
that.
might have been well advised to follow that suggestion made in relation to his own earlier judgment in Re N.
Yes.
Um,
Yes.
On you just made a point about the local authority having put up 3 possibilities in October.
Yes.
I think we have to, however, take account of the fact that the placement order, the placement application was not made until the 19th of December.
No.
And so it's not until the local authority, which it tends to do at a later stage in proceedings once the assessments have been carried out, issues an application for a placement order, not just
Yes.
within care proceedings.
Yes.
From that point on, the local authority did not put forward fostering as a
No.
realistic option,
No.
and it couldn't have put adoption forward as a realistic option before it issued an application for a placement order.
Well, it did, in fact,
Well, I think it talks effectively about the children being put there to await, or C being put there to await, doesn't it, in the earlier document.
It may be worth looking at the earlier statement, which is in the supplemental bundle.
The statement of
The statement
October
of
the
social
17th of
worker
October.
Yeah,
Yes. Page.
so sorry. Yes, it's B1, which is page 20 electronically.
Is it at 51 of the electronic bundle?
Yes, when she starts to do the balance.
The realistic options analysis.
Yes, that's it.
So an early permanency placement,
Yes.
which is one that might become a
Foster to adopt or something like that, presumably.
then foster care together.
Foster care together, and if one looks there, the advantages would promote the ongoing sibling relationship. Factors against: J can at times be aggressive towards C. K tends to take over the parenting of C. Nothing there about difficulty with placement or the respective advantages of adoption. So at that stage it was being thought about, and none of those objections that one might have to a foster placement for all 3 together was raised as a disadvantage.
I mean, again, it's just perhaps me, but to talk about there being an ongoing sibling relationship, it looks like the ongoing sibling relationship there is viewed from the perspective of J and K, as opposed to the ongoing sibling relationship from the perspective of C.
Well, I can see why you say that, my lord, but that's not what the heading in the left-hand column says.
No, but okay, but just
includes all 3.
what perception or otherwise of an ongoing sibling relationship would C have?
It was accepted that there was an attachment between the children that was of benefit to them.
That's not quite the point I'm asking
It was-
about. I don't doubt that there's a relationship which is a benefit to J and K, but at this early stage, what relationship can it be said that there is from C's perspective?
Well, one's looking at welfare throughout the lifetime of the children. And when one's considering options for permanence, one has to look at it not just as at age 1, nor even during minority only, but throughout their lifetime into adulthood.
Right, so they were together for 6 months, and
Yes.
it might have gone on.
Well, I
That they'd
think,
be together, but it won't.
my lord, this is looking at the benefit to the children if they are brought up together. So, as at the 17th of October 2023, the local authority was contemplating that option, that they're brought up within one family, and that they have the benefit, and we say a significant benefit, of growing up with their siblings as one family unit. And the disadvantages are not said to be difficulty in placement, or indeed the lack of permanence that comes with adoption for C. So it was something that the judge was entitled to look at, that if these children, and he didn't have good information about what was available, but if these children could be in a foster placement together, there would be a real benefit to them in terms of being able to grow up with their siblings in one household. And even if they were in foster placement, two older ones together and see separately, they would still have the benefit of having regular positive time together as they grew up, and indeed also a time with their parents that was also considered to be of benefit to them. And so there was, we submit, a realistic option there which needed to be considered. And by the time we get to December, neither the local authority nor the Guardian has it as a possibility.
Do they explain why not?
No. No, and that's one of the areas in which the professional analysis was lacking, and we say the judge was right to say that it was lacking. And we have several other documents that simply say, in light of C's age, the care plan for adoption is in her best interest, including, for example, at E379, which is the conclusion reached by the head of service. And as the judge rightly says, the conclusion is based on age rather than any of the other factors. And what the judge was saying in his judgment, we say rightly in paragraph 31, E104, was that regardless of the age, you have to conduct an analysis. And it's not permissible to go straight to adoption if parents and wider family are ruled out. And he says if one did that, one could never satisfy the requirement for an analysis or satisfy the nothing else will do requirement. And if one looks, he does record the social worker, paragraph 32, as saying it's all about age. Similarly, the Guardian, and the Guardian's position was exactly that it was because of age. The Guardian, in his analysis, doesn't really consider anything other than adoption for C, and the judge was entitled to be critical about that. He said and concluded and found that he didn't have a proper professional analysis. And he then said, so I have to conduct my own. It was right to conduct it.
I'm just trying to... Unless I misheard you, you submitted that the approach of the local authority had been that because C is 1, it has to be adoption.
Yeah. Well, there are several points at which that is, we say, that's what they say. If we look at E318,
yes, sorry.
E379.
So who's talking at these? You've given us 379 before. Head of service. Who's talking at 318?
This is the social worker who had been the social worker until December.
Yes. So we'll come to the Guardian in a minute. But sorry, can I just get through this sequence? What is the page reference to the social worker? You keep giving references that have letters in them. I need the
final statement.
Yes. What is the
analysis of realistic options takes place at the electronic page 361.
Thank you. So this is where we. 361.
I just am not following these page numbers.
It's in the supplemental bundle, isn't it? Yes, I'm told that Malena, Julia and I have different page references to those which the court seems to have.
Right, well, don't worry about that. We'll get there. But the statement that you're referring to is which statement?
Yeah. If you could put in F211 to the search.
Right. Well, the page reference for us is going to be F211.
Yes.
That looks like 288.
288, yeah.
Thank you.
Right. So what part are you looking at?
It's where the evaluation of the options takes place.
Right. So it's the due to her young age. Yes.
Yes. Yes.
Right. So that's the first reference.
Yes.
The second one was to the head of service.
Yes, at 369.
You gave us 379.
I'm sorry. 379 is the conclusion.
Right. Anybody got any thoughts about where that is to be found in our bundle?
I've got it at F272. F272 is right for that one. .349 electronic, thank you.
Thank you. Right. Well, this is not the head of service, this is the IRO, Independent Reviewing Officer.
I think it's signed by the social worker.
Yes?
Yes, it's signed by both the team manager and the social worker, Miss Richards.
Yes, but it's not the head of service. I mean,
No.
it's signed off by them, but
Yes.
the quote that you've given us is to the IRO.
Yes.
Right. Then we have...
But they agree with it.
the Guardian. Can we go
Yes.
to the
Guardian,
core bundle
the
366?
same is 386, yes.
366 core bundle.
Combined final analysis in both the care and placement order
Right.
applications.
So this is in the grid.
Yes.
3-4.
Core bundle 365.
Permanence analysis, yes. No order and so on.
Yes. Right. No order. No. Safe reunification. No. Kinship care. No. Permanent long-term fostering.
Yes. And then what's said about C in light of her age and circumstances. Circumstances are not defined anywhere.
Yes, but what is it that the judge found lacking in that
That there had been
statement, which is firstly as to fostering, and then the other side of the coin, adoption, the following page?
Yes, it was the simplistic way it was said that not an option in light of her age, and no analysis as to what the circumstances apart from her age were, which meant that it wasn't viable.
Right.
And so, and the judge is saying in his judgment, as we understand it, that the evidence was along the same lines, that it's to do with her age. And he had not had a professional analysis of any other factors apart from age that meant that fostering was not viable, which is why he says he has to do his own analysis.
Okay.
So our submission is, yes, there are some flaws in the judgment, but they're not fatal. There's enough there to show that the judge did a balance, did a welfare balance as he was required to do. And he factored in rightly the importance that all professionals saw in relation to ongoing relationships between the children and their parents on the one hand, and their siblings on the other. But I would, unless I can assist further with those matters, I would like to deal with whether this matter should be remitted if
Of
you
course,
are
absolutely.
if you are against us on our
Well,
primary submission.
this is a counterfactual, so it's completely
Yes.
hypothetical. But we need to hear from you on, as indeed we need to hear from everybody on all possible aspects of the matter.
Yes.
But now that we move to this point,
Yes.
although we haven't yet got there and may or may not do so, that this discussion now takes place on the basis that we've found that the judge's decision cannot be upheld,
Yes.
and that the reasons obviously remain to be expressed.
Yes.
But let us suppose the reason the judge's decision cannot be upheld is because he simply didn't take into account the most important aspects of the case, namely this child's need for a family of her own and the obvious problems that exist for a child of her age in foster care.
Yes, I would not, with respect, identify with that being the most important matter. It was one of the matters to be balanced against the other matters, including the other important matter of her knowing her siblings and her parents as she grew up, and bearing in mind that wherever possible, a child should be placed with their family or with such family members as it is viable to place them with, and in this case that would be the siblings, because we are not challenging the judge's decision in respect to the parents' ability to bring them up. And so in our submission, it's not right in the hierarchy of importance to say that the permanence that comes with adoption ranks higher for a child of any age, including a young child, than the sibling relationship and the ability to maintain that within a foster placement, as against the ability to maintain that within an adoptive placement, which is clearly going to mean that the nature of the relationship is very different. And we pray in aid all the recent thinking about adoption and the importance to children of knowing their family as they grow up. And I know that feeds into other matters, such as whether the matter should be remitted and whether there should be a contact order. But in our submission, it's not right to say that in the hierarchy of importance, the most important factor was stability, adoption, etc. So I move on then to the issue of whether a placement order should be substituted. We say that there are magnetic reasons why it should not, even if this court decides to allow the appeal for any reason. And one of the most important reasons is that at the time of making a placement order, the court has to consider the issue of contact. And our primary submission in relation to that is that this court simply does not have the information it requires to make that determination, in particular as to whether a Section 26 contact order should be made. That would involve an evaluation of the benefits of ongoing contact against any negatives, such as potential impact on finding a placement. My Lord Justice Davis made the point to Ms Cottrell that there was going to be a search for adopters who could accommodate contact, but that is proposed to be a 3-month search, so very time limited. It is apparent from the document attached to our first notice to admit, which is the LAC review, that there is a note here that sibling contact had been taking place but has not taken place recently. Now, we don't know any more detail than that, but it does suggest that despite the judge's finding and direction that contact should take place at the rate of a minimum once a month, for some reason it hadn't been taking place as intended, as he intended. I can't help with the question why there wasn't a contact order. But it does have to be set against the assertion by this local authority that they will promote contact and ensure that it happens, because even in the context of a child not being placed, sibling contact seems to have not happened for a period of time. I'm afraid I can't assist the court with how long, but there is a note here that it was confirmed that this should be arranged by the foster carers of the two elder ones and the foster carer of C. And so, even with an appeal pending, even with the importance that is said to be attached to ongoing sibling contact, it hadn't been happening. And one knows what comes from the authority.
You make that statement on the basis of the note, but we don't have information, including information that you're in a position to provide with regard to your own contact.
Yes, the parents have had contact once a month.
Well, your client had contact 3 times in 9 months. To the date of the hearing.
Yes, it happened, but he's, as I understand it, had contact in June and in July, and is due to have another contact in August.
Right. So that is very much as it should be.
Yes, I was addressing the sibling contact.
Yes, but what steps have you taken to find out what that is, apart from reading out something from a document which had not yet been admitted? I sense that if we start going into this hasn't happened, that hasn't happened, we're going to have to hear whether it has or hasn't been happening, and then we're left.
Well, it's perhaps for the local authority to explain a note in a looked after child review which says that sibling contact hadn't been taking place. My client doesn't know the answer to that question. We have asked the local authority for various documents. We haven't specifically asked that question, but.
So your point is that effectively they can't be relied upon?
Yes. And we also make the point that was made clear in the authorities, for instance, VB, that the difficulty of imposing contact on adopters unless there is an order, because, and that's another reason why, if the court considers that it's right to look for a reasonable time at least, or generally for adopters who can accommodate contact, very much the modern approach to adoption, then there should be an order so that that expectation is clear. And the search should focus in our submission on those who can accept, as we say is now the way in which adoption is going, contact, and not just trust that it will happen, but focus on there is this expectation, there is this court order that contact will take place however many times is appropriate, and you must accept that if you're going to adopt this child. And our primary submission is that if the court reaches the point where it's contemplating a placement order, it's not in a position to consider first whether a contact order should be made at all, and second what the terms of that order should be. If this is a child who has a particular need...
But why not? For want of what?
For want of knowing enough about this child's characteristics, her stage of development, the benefit that will come to her.
What has changed since the judge's decision?
Well, we know that she's got some significant learning delay.
But this is weeks. I mean, there's got to be a sense of urgency about these cases. That
yes.
This child is entering into one of the most important periods of her life.
Yes.
The period between now and the age of 2.
Yes.
Well understood to be an absolutely crucial time.
Agreed.
And I mean, every suggestion has got to be balanced up, and I understand that. But I mean, in order that we should add to delays, if we got to this point, we would have to be satisfied that it justified the cost of delaying planning. So what I'm trying to find out is, sometimes it's said, well, it's not appropriate for this court to make an evaluation.
Yes.
Sometimes it's said, this court doesn't have the information that it would need to make an evaluation. Now, you seem to be saying the second.
Well, I'm saying both. You don't have the information, therefore you can't make the evaluation.
Well, exactly, but it isn't to do with the competence of the court to make an evaluation. It's to do with the material that's available, you say.
Yes.
And I'm asking you, apart from what you've shown us in the fresh evidence application, what else there is that would justify a delay.
One would expect to have some idea of what the impact of a contact order would be on the placement options.
So the local authority would have to go away and ask lots of people whether they wanted to adopt on these terms and then report back.
It's not really that. It's more the family finding department ought to have some information about how adopters view.
Yes, well, adopters don't generally
Yeah.
find it easy,
No.
but they can be encouraged.
Yes.
What is going to be known, that you've already been told that 2 adopters have pressed the pause button because
Yes.
they want to know the outcome of the medical
Yes.
situation. But what else is going to be gained by delay? We know that the situation that adopters will take.
Well, it's also not just the question of whether there should be contact at all, but the form the contact should take, the frequency of contact. Those are things which the local authority might have had before the court in terms of their pool of adopters and what they're prepared to accept.
Right. Well, I've understood what you say would be gained factually.
And it's very important for this child in a context where all the professionals were saying that ongoing contact, not just identity contact, but something going beyond that, was important and
Yes.
of benefit. And if one looks at the frequency that's proposed, one can see that it's rather more than the old-fashioned traditional, certainly not letterbox only, and one knows what's said about letterbox contact these days, but it's face-to-face, direct contact on a regular basis. And if that is what this child requires, then if the court feels able to make an evaluation, it should follow the regularity that was proposed, which is 3 times a year by way of an order, because that's what it came down to in the end in the evidence.
There's 3 times a year before adoption order and twice a year after.
Oh Lord, I hope I haven't got that wrong. I thought it was 3 times a year with indirect in between. That was proposed. I'm just turning my back.
It's whatever is written in the care plan.
Yes. Oh, right. Okay. Right. Sorry, my learned junior's dealing with another point that my lord mentioned earlier about the father having only attended 3 times in 9 months, which is, I am told, incorrect. When he did leave the residential placement and didn't go to contact there as often as he should have done because it was a very difficult journey.
Yes, so nobody was blaming him for it.
But after that, he has attended religiously, I'm told. Oh, thank you very much. No, in fact, it's rather less post-adoption. What's
Yes.
proposed is twice.
Well, it's basically
Limited
it's winding
letterboxing.
down until, if we were to start the clock running now, it's winding it down until the end of this year, by which time it would have reached 3 times a year. Then after adoption, twice.
Yes. Well, we would submit that isn't sufficient, bearing in mind the importance of
Yes.
the relationship and the need to have a relationship that's not just a minimal, a little bit more than identity contact, but not much more than that.
Now, since you're in a position to take instructions, but not to do so now, you've told me how often the father didn't have contact, as it were. Namely, I was wrong, because I think I was following what was said in the papers, that it was 3 times. You'll tell me at some point how many times it was between the time of the hearing and the time that he left the placement. But don't
The time
interrupt.
of the hearing and the time he left the placement.
To the time of the hearing,
Yes.
9 months.
Until the hearing. Thank you. It was weekly and there is a record at F249 that he was attending. And at F244, there is a note that he was prioritising contact.
Yes, well, what I'd like, please, at the end, is just how many times.
How many?
Yes, how many times?
How many weeks? Yes.
Thank you. Well, I think the mother's seeing 3 times a week.
I don't know if that's still going on. I think it has reduced.
Reduced, but it... Well, I think the best thing would be if at the end of the hearing you could please put your heads together and just provide this basic information, because it's in the papers, but it doesn't seem to be common ground.
No, I'm sorry, we will check that. We will check that. Then, my lord, I think I made the point that the other reason for not...
The first is to do with contact.
No, the other reason for remitting is the absence of information since the hearing, and all these assessments and so on that may be relevant to the decision.
So it's not just about the response of the doctors, it's also about subsequent events.
Yes. Thank you, my lord.
Can I just ask you about one slightly unusual feature of the situation? Again, what we're doing is we're moving from possible outcome to possible outcome, and we may not get to any of these depending upon where the appeal ends up. But if we were of the view that the judge's decision could not be upheld, that we were in a position to make a decision in relation to the application for a placement order, but let's say there was some substance in your points just made now, which is that the court would have to consider contact. My reading of sections 26 and 27 are that it wouldn't prevent the court making a placement order if it thought that that was the right order to make, and remitting the question of contact if it thought that that was really necessary to do, because in order to do that, it would have to be satisfied that a placement order is the right order to make, regardless of whether there was or was not a contact order and what the level was going to be. In other words, it's not required that the contact order has to be made on the making of the placement order, although it can be.
Well, I did consider that over the short adjournment, and I took the view that when one looks at section 26 and 27, what is expected is that the court, at the time of making a placement order, will not only consider the issue of contact, but also consider the making of an order.
Well, it has to consider it, but an order can be made at any point from the making of the placement order until the making of an adoption order. There is no particular point during that window when a contact order, if it was going to be made, should be made. It can be made at any time. It can be made on application.
Yes, but once a placement order is made, that would mean that there would need to be some basis on which the parents could continue to be part of proceedings, presumably only in relation to contact.
Yes, but it would be. I mean, I appreciate we're talking about a very unusual situation here, but it would be that on the making of the placement order, issue of contact remitted.
Yes.
So in other words, a decision was being taken at the time of the placement order, which was that it should be decided, but decided by somebody else. I'm speaking purely hypothetically. May not be a good idea at all, but just want to know what your submission is as to the court's power.
I think it's difficult with respect, because it's not the way in which the section is drafted. One would expect the local authority to have some input into that issue of what the contact should be at the time of the making of the placement order. The court would have to conclude that a placement order is right regardless of a decision about contact.
That's the whole premise of my question to you. Yeah. That if it did that, then it seems to me that it would be wrong in principle to, having reached that conclusion, then unreach it in order that the question of contact could be considered by somebody else. That's what I'm saying, and I don't see anything in 26 or 27 that prevents the course that I'm suggesting, although it's clearly a quite
It would be a very
unusual state of affairs.
It would be.
Yeah.
So I'm just trying to follow this debate, but are you saying that 26.4, sorry, not 26.4, 27.4
No, 27.
and 27.5,
Yes.
I mean, it's unusual wording before making a placement order, which you think is fairly clear. The course must consider the arrangements and invite the parties to comment. But it doesn't say you've actually got to provide for the contact before making the placement order.
No.
And then
I mean,
subparagraph 5 seems to be permissive. I mean, is that the only place that there's any reference to the court making or provision for contact?
It isn't express that it has to be done before a placement order is made.
The other order the other paragraph that's relevant is 26.4.
Yes.
Which is that when making a placement order, this is one of the occasions where the court may, on its own initiative, make an order under this section. So that's one route into making a contact order while approving a placement order. But I'd say it seems to me that making an order under this section could quite possibly include doing what I've suggested, that consideration is going to be hived off. But it's unusual.
It's not the structure of the section. I accept the neither section prevents that by expressly saying it can't be done in that way, but it is always considered that it's appropriate at the time of making a placement order to factor in considerations about contact.
Anything else?
You say factor in.
Yes.
I mean, there's nothing in statute that says when you make a placement order, you must make a contact order of whatever description.
No.
I'm assuming that proceeds on the assumption that in many cases it can be left to the local authority.
Yes.
To deal with that up until the point of the adoption order, when the court may or may not interfere.
Yes. It is usual, as part of the consideration about whether a placement order should be made, to look at the arrangements for contact.
Yeah.
Well, that's what is happening, as it were.
Plainly what the statute says.
Sorry,
that's the extent of it.
Yeah.
But it's very unusual to say a placement order should be made regardless of the fact that we can't look at the arrangements for contact and consider as part of the overall decision which contact should take place, because the plan for placement should set out what contact is contemplated. If the court's endorsing that, it should consider what the arrangements are and whether they are appropriate. And so it's very unusual for the court to make a placement order without being in a position to look at the arrangements for contact as part of the overall decision.
Well, you could probably go further than that. Might be unprecedented.
Yes, I don't know of it ever happening, but that doesn't mean it hasn't happened, of course, but I think it would be extremely unusual. I can't say based on the law that it would be wrong, but it would be very out of kilter with the importance of contact in this case to this child, with the usual practice of the court. I submit that it would put any judge considering it who isn't the trial judge below in a very difficult position.
Yes.
Because it wouldn't have, I appreciate they'd have the judgment of this court, but this court wouldn't be able to give any guidance as to how contact should be dealt with. There are a number of difficulties.
I see a lot in that, Ms. Bailey.
Thank you.
Thank you very much. Anything else, Richard? No. Thank you. Yes, Mr. Miller.
Well, my lords, picking up your previous comment, I will be very short.
The floor is yours.
Thank you. In terms of the contact, may it be couched in terms of good practice for a judge to at least consider a final care plan where contact provisions are set out, because there may well be some discussions in submissions about what the frequency or level of contact shall be. It may well be, if I may from experience, that judges will give an indication as to what they believe any contact should be post-making of orders, whatever they are. So I do agree with my learned friend, Paisley's King's Counsel, that it is something that a court will consider as part of the overall welfare decisions. In terms of Ms. Paisley's submissions as well, I would have to accept that it is not a carefully structured judgment. The last point I wish to make, my lords, is that in discussions, my lord, with Miss Paisley, you looked at various perhaps hypotheticals or positions, and you talked about it's obvious in C circumstances. I'm not quite sure where the court was going with that particular comment, but it is, I would respectfully submit, a dangerous way to approach, because essentially it takes away any linear approach that we know we mustn't be applying and moves straight, as it were, to the end game. That is, it's obvious in C circumstances to approve the care plan in terms of placement. So I say that cautiously because I wasn't quite sure why that was mentioned. It may
no,
be
what I'm thinking about is a situation where, for example, to take the Guardian's report as being probably the only place we've been shown where a full range of possibilities was set out, where one sees the thought process, that all the attention was following what the parties were arguing for. Yes. You wanted the children to go home, quite understandably, and the local authority wanted one of them to be adopted, and so that was the contest that was mainly taking place. And your fallback position was that they shouldn't be adopted in any case. C shouldn't be adopted in any case. What I was trying to convey was that somebody goes down the list of those and is able to pass very swiftly away from one of them because it is striking how inappropriate such an outcome would be. That one obviously devotes time to particular options in accordance with their deserts.
Yes.
And so clearly that is why, in this case, nobody focused on the suggestion that the judge came up with at any great length, because the only people who were capable of delivering it were people who thought it was a non-starter. That's really what I was trying to convey by obvious.
That's helpful.
In other words, an abbreviated thought process, not a no thought process at all.
Thank you. My last point, if I may, is remitting the placement application. I would agree again with the submissions of Ms. Paisley. To put it in general terms, it is such a profound welfare decision a court has to make. But more importantly, that if you are to decide that the appeal should be allowed, essentially what you are saying is that, or part of it, is that the realistic options was not properly analysed, particularly by Children's Services and to a large extent by the Children's Guardian. And that is an important decision for any court to make. Now, if that evidence wasn't there at first instance, it certainly isn't here with respect to the Court of Appeal to make that decision.
Well, can I reassure you about in this way, that one of the reasons why we would definitely remit something is if an appeal was allowed simply on the basis that the judge's judgment or reasoning was inadequate. If it were just, it hadn't got to grips with the decision. So if that was the only basis for allowing appeal, one would have to remit.
Yes.
But similarly, if there was a gap in the evidence that was important to the decision, one would have to remit, because we couldn't make it up ourselves.
Yes.
But there's a third possibility, which would be that it wasn't just that there was faulty reasoning and no gap in the evidence, but that the only possible outcome that the judge could have reached was to make a placement order. That's the alternative situation that might arise once we've considered all the arguments. In that situation, there wouldn't seem to be much purpose to remitting it, because we wouldn't know what to tell the judge who was hearing it. You can't remit it to a judge and say the only order you can make is a placement order.
My Lord, I take that point, but I think I must raise that on behalf of...
No, I understand that if it's for other reasons, they give rise to all sorts of different needs for caution.
I'm grateful. No further submissions unless I can assist on any other point.
No, thank you, Mr. Miller.
Grateful. Thank you, my Lords.
Yes, now, Mr. Peirce, can I hope that you're able to tell us that legal aid came through.
I haven't been instructed otherwise that it was a difficulty.
Well, I mean, maybe they're not telling you you're not getting paid.
I was instructed very late at the end of last week, so I assumed it had.
I know, but it was clearly important that C should be represented on this appeal, so if it turns out that you're acting pro bono, could you let us know?
I will do.
Thank you.
My Lord, the submissions made on behalf of the local authority, both in terms of the law and the analysis of the judgment, are fully adopted by the guardian and the children's solicitor. I have a few supplemental points that I would like to make, the first of which is, and I know the court hasn't yet determined the relevance of the nurse's report from February and whether it should be admitted. I did have the opportunity to briefly speak to the guardian before this afternoon's session and took instructions on several points from him, that being a relevant point that we had to address. Now, in February, it was being evaluated that C was demonstrating global aspects of delay. Clearly, that's relevant to the thread throughout his honours judgment in relation to potential for genetic loading, and it's a relevant welfare consideration. But what the guardian says is, well, when the foundation assessment concluded in November and was negative, as was mirrored by the previous proceedings, the primary aspect of concern was about stimulation, proper care and provision being given for C, and that on an evaluation, and this is not being disrespectful to the health visitor, as of February, how could one distinguish whether that was as a consequence of the adequacy of the parenting that had been evaluated, or whether it was to do with any aspect of genetic loading that may be manifesting at quite a young age in the guardian's experience. I make the same point with reference to the child looked after review minutes, where en passant references have been made again to autism. It is very, very early in a child's development to be making those considerations without a higher level of expertise and time. Returning to the aspect of
So where do we take that submission?
well,
So what's the bottom line?
well, the bottom line, my lord, is even if it is considered relevant, it would have just been a part of the welfare consideration in April in any event, which whether there is a genetic predisposition for C, that means that she may or may not develop both educationally and developmentally in a delayed manner that may be problematic for any long-term foster care and or any adopter. The guardian's analysis in that is every week in the family courts, there are children who have got parents with genetic difficulties in terms of cognition. There are parents who have got severe mental health difficulties that mean that a child may or may not, in adolescence, develop a mental health difficulty. There are children who are severely traumatized by their circumstances. And tragically, there are children that have all of those considerations. That does not preclude, on a welfare analysis, that child having the possibility of having a secure long-term placement with a permanency adopter, as opposed to looking at considerations to whether those aspects of that child's potential require them to be looked after in the Guardian's analysis, a more unstable environment of long-term foster care.
And might it be said that it's actually in the child's better interest to be looked after in an adoptive environment, in an adopted family, if, save in the most extreme situation, they will have a greater likelihood of parents who are committed to them because of the nature of the relationship in an adopted family? How does it play out? I mean, in the Guardian's view, in general terms. I mean,
the Guardian's view would be that regardless of what may be the trigger point for the worst case scenario welfare evaluation, outcomes for that child will be better with a sense of security, stability, permanence, and dare I say love within a family that will nurture the potential that they have, as opposed to the alternative route where there may be structural impermanence. There may be many reasons why a foster carer may have to cease working as a foster carer. The outcomes are globally known for children who have multiple placements throughout childhood. And so looking at what may be the core potential, the Guardian's view would be that permanence is more likely to ameliorate any innate difficulties or early developmental years difficulties, which would require a permanent sense of commitment to the child. And in adolescence and adulthood and through life, that would mean that that child is likely to have better outcomes. And I say that the Guardian specifically instructed in the Lord that the criticisms that the professional analysis was inadequate, the references made that there was a lack that required the judge to then conduct his own analysis. The Guardian instructs that he was cross-examined for around an hour. He was asked extensively about the pros and cons of both long-term fostering as set against adoption. That being a length of time that he says is more unusual nowadays.
I'm a bit concerned about this, my lord. It's not before you, it's not part of the bundle. We don't have any transcripts of evidence. We don't know what was asked of the Guardian. And for this to be effectively evidence being given on submissions for the Guardian is not a happy way to go about it.
Yes, well, can we approach this in a different way, Mr. Peirce? Yeah. Rather than giving a factual account of this, on a legal analysis, does the Guardian accept that the information that was available to the judge was inadequate?
I don't have instructions specifically that he considers.
Right, well, I'm asking on a legal level, knowing what you do about the law and practice, procedure in the family court, was there anything about the presentations made by the local authority or by the Guardian that you would either assert or concede was lacking in the manner that the judge found?
I wouldn't, my lord. The Guardian sets out each consideration for each prospective pathway, whether no order, return to the parents, fostering or adoption. And it might not be elaborated upon to great length in each of the subsections that the Guardian addresses, but they're properly addressed. in a past age, they would have been lengthier, I know that, but in the current age, it appears that they're much shorter in their analysis, and then in oral evidence matters are picked up.
Right. Where do we go to next?
My Lord, the point really, the last point that I would like to make submissions on is the issue that was raised is whether the matter should be remitted or whether the matter should be determined and a placement order made. I've explored that with the Guardian. His view would be that if the matter were remitted, given the listing factors in the Reading area, it would be likely they wouldn't get a listing until the end of the year.
Well, it's not particularly surprising, but even assuming that one could do better than that, I think one has to approach it on the point of principle and not of consequences. If it needs to be reheard, it needs to be reheard.
Yes.
And obviously one is reluctant to build in delay, but if you've got any submissions to make about the principle of the thing?
The principle of the issue is the Guardian is of the view that all relevant matters were set out by the local authority and the Guardian at the hearing in April, that there was sufficient professional analysis for the court to have reached a decision that on a welfare analysis the making of a placement order was the right order to make, and it was proportionate and it was necessary, and that wasn't the outcome that was reached. The Guardian doesn't feel that the reasons are adequately explained as to why that decision wasn't reached, and is of the view that if it were, number one, if it were remitted, it would cause delay. I accept the point that that isn't the core principle of the matter. But his position would be that a placement order should be substituted by this court.
And what do you say about contact?
I've got no instructions on the section 26 point. The Guardian was, in his report and in his evidence, and I think this is right, how the judge evaluates this, it was the Guardian that was making the suggestion that there be contact for children and parents. And he maintains that position. The care plan is twice yearly. The Guardian hasn't gone behind that.
Just for completeness, Mr. Peirce, we're grateful for your attendance. Is there any particular reason why the Guardian himself is not here?
He was engaged in the final hearing.
Thank you.
Well, can I mention one point?
Of course.
Mr. Kiani, who sits behind me, is acting pro bono.
I had noted that, and it's much appreciated.
Thank you, my Lord.
Yes, any reply, Ms. Potter?
Just very briefly, my Lord, if I may deal with one matter, which is the point raised by my Lord with Miss Baisley about section 26 and section 27.
Yes.
Just looking at section 27.4 and the obligation of this court, were this court to reach the conclusion that the placement order should be made, the obligation on the court set out at section 27.4 is that before making the placement order, and this is at page 424 of the authorities bundle.
Yes.
The obligation is that the court must A, consider the arrangements which the adoption agency has made or proposes to make. Pausing there for a moment, my Lord has looked at these already, but the arrangements the local authority proposes to make during the currency of the placement order are as set out at page 343, the final contact plan, as it were. My Lord looked at those this morning in discussions with me again with Miss Baisley, and that tapers the contact down to 3 times a year pre-placement order, pre-adoption order, and twice a year thereafter. And then invite the parties to make submissions or to comment on those arrangements, and the court has done that if the court is contemplating making a placement order. I would reiterate the point that we made earlier, that if the court is satisfied that the local authority is committed to the arrangements as set out in that care plan, then there is no need for the court to make an order under Section 26 mandating those arrangements. My Lord Justice Jackson indicated to Miss Paisley that we were going down something of a rabbit burrow if we start looking at whether contact has or hasn't taken place.
Well, doing so in submissions.
No,
I think
course.
what I'm minded to do, as we appear to be coming to the end of the hearing quite shortly,
Indeed.
is that we'll rise just to give you the opportunity to put your heads together and agree a broad account of the situation, rather than troubling you to go into your files and write documents and so forth. So you will obviously have your instructions,
Of course.
and those can be fed into that discussion.
Thank you. My Lord, those are the only points I wanted to make in reply.
All right. Well, we will, if we may, rise for 5 minutes. Could you please just do your best to tell us in the father's case, because it starts earlier in time,
Yes.
what the contact has been up until the time of the judge's hearing.
Yes.
In the case of the mother and the children, what the arrangements have been for parental contact since they left the residential address, and of sibling contact during that time. We do not need dates. We don't need precise numbers. We just want to get the general picture so that it can be accurately recorded. Let us know when you're ready, please.
Do you want to deal with your client and we'll deal with...
Can you tell us
Yeah.
about the siblings? Because, I mean, it's quite difficult.
I'll take instructions.
Yeah.
Just give me 2 minutes.
And likewise him, and then we'll do our best.
Yeah, that'd be cool. Yeah. So, yeah, what was it? So, from residential. From residential now. I've got that.
You've got this the hearing.
It's actually for the care plan. It's been working
So residential till the hearing.
from residential.
Yeah.
All right.
Yeah, it's just cooler in here. Or will you come with no foot? So we've got essentially he went whenever he could, whenever it was open to.
I'm just waiting for everyone to come and join me. If you can give me 30 seconds for that to happen. Thank you. Yes. No, thank you.
Yes, I think so.
Yes, thank you.
It's reducing the amount of care for them, so we'll do every other next month. A brave decision, I think. They do make it. Yeah. I find it much easier now. Actually, I've done
Do those two. You can take these on back. No, I'll give it to you in a second from what we've been told.
We're fine.
Thank you very much.
All rise if able.
Yes, Miss Fudge.
My Lords, thank you for the time. To deal first of all with the question of the father's contact during the currency of the proceedings. It is right that he did not attend while the children were in the residential placement beyond 3 contact sessions. But once they left the residential placement, and by that I mean all 3 children, the father attended all of the contact that was offered him, and he did so religiously, if I may put it that way.
Yes.
Ms. Baisley's solicitor has indicated that is around 20 sessions. We take no issue with that.
Well, I obviously may have picked up the wrong end of the stick, but I got from somewhere that it had been very much less than that. Clearly I misunderstood the period that was being referred to, and it's been good that that has been corrected.
Yes, indeed. Before the final hearing in April, the children were having contact with the parents twice a month. Since the final hearing, the children have been seeing the parents fortnightly.
We're talking here about
all 3 children together.
Yep.
Seeing both parents together.
Yep.
And that has been fortnightly, or forgive me, monthly. So
since the hearing.
Sorry, unhelpful. Fortnightly in May, so 2 in May.
Yes.
And then monthly in June and July. August and September, obviously, still to come. Alongside that, the 3 children, siblings, were to have contact separately with each other to be arranged through foster carers monthly. That took place in May, on the 4th of May, I believe. It did not take place in June because C was ill. And it did not take place in July because there was a logistical or practical issue for the foster carer for K and C, or K and J. There is a scheduled contact for August. So if the local authority's plan was adhered to and was effective, allowing for children being ill and so forth, the children should be seeing each other twice a month, once with their parents and once in a separate sibling contact. That's the information that I have.
The broad picture is that the plan is in effect, but for the 2 occasions that you described as being missed in June and July.
Mm-hmm. So they've seen each other, I think, 5 times since the final hearing.
All right. I stress that we were not concerned with the exact accuracy of all of this, and I'm reassured to hear that there's been this level of parental contact, which I hadn't picked up in the father's case. Does anybody else want to contribute anything on that topic, or do we now have the picture?
No, thank you very much. No, it's...
Well, if Mr. Robertson is happy, then we're all happy. Very well. Well, can we thank you all for the work that has gone into preparing this appeal at quite short notice. We will have, as you can tell, done some thinking about it already. We'll give it further thought. I hope that we will be able to let the parties have our decision quite rapidly. And we will do that by handing down judgments electronically, which you're of course welcome to share with your clients on the basis that they're not further disseminated. And we'll ask for your help, please, in relation to any editorial corrections and the creation of a draft order. By saying quite rapidly, and I don't want to put anybody under particular time pressure, but I hope you will have a decision this week, because we're aware that this is a very anxious question indeed for everybody involved. Because we won't, in the normal way, be giving our decision in court with everybody present, I can only say that we've considered all the arguments. We'll give them further consideration, but the parties should they should prepare themselves for all possible outcomes in relation to our decision. Is there anything else, Ms. Bottrell, or any other party? No. Thank you all very much indeed.
That'd be really helpful.